yourselves first. Welcome to class.
Okay, like I said, we are McKendree University. I'm Caitlin Schleter.
I'm Zach Fieber.
And I'm Yvonne Hilsman.
Our topic is appearance-based discrimination in the workplace. In order to effectively present this topic, we decided to research cases that showed where this type of discrimination took place and then analyze them from a financial, legal, and most importantly, an ethical standpoint. This topic was important to us and interesting to us because of its subjective nature, meaning that there is no clear-cut illegal or legal outcome of the case if there were to be a lawsuit. And also because of the fact that it can be seen across all areas of business. Being such a subjective topic, we understand the problems that may be faced and the difficulty that a company is trying to enforce preventive practices and procedures. There are laws that protect against age, race, color, and gender discrimination, but the appearance does not fall under these regulations. We understand that this may make it difficult to eliminate, but it does not make it impossible to control within a workplace. The case we decided to focus on is from 2012, where an Iowa state court upheld a dentist's decision to fire his assistant because she was viewed as too attractive for his workplace.
His wife.
And for his wife, yes. Yes. Melissa Nelson, a 32-year-old assistant to Dr. James Knight, who was 53, was fired because she was seen as a threat to Knight's marriage. Nelson worked for Knight for nearly 10 years and viewed him as sort of a father figure and a mentor. In the last couple months of her employment, he began making comments regarding her appearance, her sex life, one stating that if his pants were bulging, it was a sign that her clothing was too revealing. Keep in mind that she is a dental assistant, she wears scrubs, and that can be as revealing as you can imagine. But and he also once stated that regarding her infrequent sex life, that's like having a Lamborghini in the garage and never driving it. A lot of these comments may have happened over text messages between the two, unfortunately, and which is ultimately what Knight's wife, who also worked in the office, discovered and then requested that Nelson be terminated. When Melissa Nelson brought this case to court, it was ruled against her at 7-0, which the court stated that while it may be unfair, Knight's decision may be unfair, it is not unlawful according to the Iowa Civil Rights Act because it was motivated by emotion rather than gender, and it was not a gender discrimination case. Knight's attorney later stated that the court got it right and it was a victory for family values because his intent was to save his marriage rather than because of Melissa being a woman. And now I'm going to pass it over to Zach, who is going to discuss the ethical implications of this case and on a broader scale as well.
Thank you, Caitlin. I think it's important to acknowledge first that we do acknowledge that there are employment opportunities such as modeling agencies, clothing retailers, where the appearance of the employee may actually directly affect how well that company does. We are talking specifically about times where the employee can do all the job requirements that he or she has to do, and the appearance does not matter. When looking at the ethical implications, we must first look at both parties involved and look at it from each party's rights and each party's responsibilities as they tie into the issue. Knight, the dentist, as a business owner, does reserve the right to hire and fire as he pleases. Iowa is an at-will state, which means that he does not have to technically provide a reason when firing someone such as Nelson. That being said, Knight, as an employer, has a responsibility to treat all employees fairly and equally. He also has a responsibility to act professionally around all of his employees, which we believe he did not do. Nelson, the dental assistant, also has the responsibility to act professionally in the workplace, which we believe there could be a case made that she could have refrained from becoming so close, developing such a close relationship with Knight, and also refrained from sending text messages back and forth. but we believe that she did nothing wrong to warrant his actions, behavior, comments, or ultimately terminating her. She has the right as an employee to be treated fairly and equally, as I stated. She, as Caitlin stated before, she wore just standard scrubs that any dental assistant would wear. So her appearance is something that in the workplace she could not control. So she does not deserve to be punished because of how Knight felt about her appearance and how he reacted towards her appearance. We believe that this type of behavior that was exhibited by Knight is very unethical, and there's no place for it in any workplace. If the appearance of an employee, as I stated, does not affect how well they perform their job, they should not be subjected to any sort of discrimination. Knight won this case, as Caitlin stated, but we feel like this issue goes deeper than simply this case, win or lose, and that all businesses, HR professionals, employers should be aware of this issue because it is a real issue that takes place in all around business. There actually, as you stated, there are studies out there that suggest that this does happen quite a lot. One of the studies that we looked at was done in 1994 by Drs. Jeff Biddle and Daniel Hammermesh, who actually reported the studies of 3 different surveys. The study was done, there was a set of interviewees that were asked a series of questions, first about their income, occupation, and background. The interviewees were then rated by the interviewers on their attractiveness on a 5-point scale, ranging from homely, below average, average, above average, to handsome or beautiful. The results of this study showed that 9% of men that were rated as homely or below average also received 9% less annually on average. 32% of males that were rated as above average or handsome also received 5% more on average. The most attractive females earned 4% more, and the least attractive females earned 5% less. We believe it is possible to minimize this issue in the workplace if things like employers, HR departments, and managers make an effort to emphasize that it is a real issue, it is important, could be important to them, and they address it throughout their company properly to all their employees. I will now hand it over to Yvonne, who will explore some of the potential suggestions and ideas we had to solutions on the issue.
Thank you, Zach. When it comes down to it, as Caitlin said, appearance-based discrimination is subjective. Therefore, it makes it difficult to have laws in place whenever every case is different. Every case that goes to law is different. However, we believe you as HR professionals can enact stuff in your company before a law takes place. Our first suggestion would be for a company to raise awareness about appearance-based discrimination. If a company put in seminars that help employees learn about appearance-based discrimination, we believe that an employee will be more aware of when it is going on. And that although an employee may feel like they understand what appearance-based discrimination is, they do not consciously know when it is happening and when it's not, because it's become so familiar in the workplace. Another suggestion is for the company to modify the existing policies or codes of conduct that they have to minimize discrimination and bullying. We need to ensure that the policies they have are up to date and that employees fully understand them, so they don't just read them and read over them. Our final suggestion is for a company to emphasize the repercussions of an event, such as the one that Caitlin discussed in Iowa in the dentist's office. Some repercussions of them is that lawsuits can be filed, and with the lawsuits come lawyer fees and legal fees, which a company does not like to deal with at all. And also, after all the court and everything is settled, the morale in the company has gone down. Employees feel awkward, and they could also feel uncomfortable, embarrassed to go to work every day because they know this is going on in their company. Although that as an HR you could push for laws to be enacted and that these laws would better protect your companies, laws take time to be passed. And we believe that you could do something right now to protect your company so that there are, although this is kind of out of your control, you can control it the best you can so that you don't have lawsuits filed against you. And there are many benefits as if you go to your company and put these plans forward. One of the benefits is to show that it shows that your company really values how comfortable your employees feel in a workplace. They don't want you don't want your employees feeling uncomfortable when they go to work.
That's okay.
Okay.
Your thought. 5 more seconds.
Another thing is that it shows that the company wants to diversify their workplace. And all of this ties into giving your company a competitive advantage so that if you want to, you can get the best employees out there. If someone knows that your company wants to, you really value all this. Okay, and then obviously you don't have the legal fits. As you can see, this topic is a real issue and can happen in any work environment. While it may be difficult to establish the laws, you can take action right now, and this would make it more respectful. Thank you.
This is